Uh, Welcome everyone to another episode of Ask a Lawyer, where we discuss workers' compensation issues in the state of Georgia. I'm Ben Gerber. We have Natalie Elkins, Tom Holder, and Chris Gifford. The first thing we're going to talk about is unemployment and workers' compensation. You may have seen on the news, and quite frankly, it's all over the news, about people getting unemployment and the government extending unemployment and so forth. And we have a lot of questions from a lot of clients about how unemployment interplays with workers' compensation. And Natalie Elkins just wrote an article about that. So Natalie, how does workers' compensation interplay with unemployment?
Well, if you're currently getting workers' compensation benefits, you are not eligible for unemployment as well. But a lot of employees are finding themselves all of a sudden out of work and asking themselves, should they apply for workers' comp or should they apply for unemployment? The answer to that question depends on why they are out of work. If an injured worker is out of work due to their injury, then they should be getting a workers' compensation check. If they're out of work due to a layoff or some other factor not related to their injury, then they should be eligible for unemployment. Practically speaking, we have a lot of clients who it's our position they should be getting workers' comp, but their comp benefits have been denied. Depending on the case, for some of those employees, it may make sense for them to go ahead and apply for unemployment. If they're successful in getting unemployment while fighting for workers' comp, at least they have some sort of financial benefit coming through the door. If they then later succeed at also getting workers' comp, their employer may have a credit. We are happy to talk to any injured workers about their options, about which type of benefit they should apply for. It really is a case-specific question, and we're happy to talk to anybody about what's their best option.
Yeah, it's a very confusing area of the intersection of law, so please don't hesitate to contact us, and we'd be more than happy to discuss your specific facts with you about your case. Another issue that's coming up is employers and insurance companies trying to return people to work on a light-duty basis during this COVID-19 crisis. So Chris Gifford also wrote an article about that. Chris, you want to talk to us a little bit about returning to work in these dangerous times?
Sure. Pursuant to 349240, your employer may bring you back to work if you are on light-duty work restrictions if certain requirements are met, including getting a signed job description from your authorized treating physician and providing you 10 days notice. Normally, when this occurs, you are compelled to return to work. However, the times that we're under now, you may have legitimate concerns about whether or not it is safe for you to return to work on this light duty job, because there's a chance that you may contract the coronavirus, which could cause major health problems, including death. The real question here is whether or not the light duty job offer made during this time would be considered reasonable. Ultimately, that's a factual determination that would have to be made by the administrative law judge. However, if you have received a WC 240 job offer, it is imperative that you speak with your attorney before making a decision on whether or not you should or should not return to work.
Yeah, just in a previous episode of this sort of Ask a Lawyer, we talked about the courts being closed. Chris, have you found that judges are available to have conference calls at this point in time, especially about an issue like returning to work?
Absolutely. The board is open. Hearings aren't moving forward, which is a problem, but most everything else can be addressed by the board. And if you feel that this is an unreasonable job offer, then this certainly can be addressed with the judge through a conference call.
Excellent. Now, it's very timely that we're talking about this, and Ask the Lawyer, because just yesterday, the governor of Georgia is basically trying to reopen the state on a slow basis. And I know that's going to affect workers' compensation. Tom, I know you've read the order. What have you determined from the governor's edict?
Well, I have a lot of questions about the governor's order. For one thing, I'm not sure how people are supposed to maintain social distancing when they're doing things like getting their nails done or their hair cut. Also, people in bowling alleys are putting their hands in balls that other people have used, or they're putting their feet into shoes that other people have worn. So I don't really know the logic behind the businesses that are being directed to, or I guess being allowed to open. I know a number of people are writing that this has to do with unemployment benefits and how they're going to impact, with whether or not people are eligible for them. There's also a portion of the governor's order, and I have to say I haven't read it in so much detail, that has given some immunity to businesses that are opening under his order. I'm not really sure how that's going to impact workers' compensation. It probably will be more in the negligence area, maybe to protect those businesses in case people go to them and then contract COVID-19. Now, whether or not that would extend to injured workers who contract COVID-19 from working in those environments obviously is still up in the air. As far as other states are concerned, other states such as Utah and Illinois have passed laws providing presumptions for people working in essential businesses. If they get COVID-19, they will automatically be deemed to have received the COVID-19 while they were working and be eligible for workers' compensation benefits. Not surprisingly, Georgia does not have that. We don't have any presumptions. Other states have cancer presumptions for firefighters as an example. We don't have that. I think COVID-19 cases are going to be difficult, although I know that there were some people who have pursued them. For one, there are people, if they're sick for 2 or 3 weeks, the possibility of recovering under these arguments might not be worthwhile to pursue. I think, unfortunately, we're going to have to see people who've actually died before it's really worthwhile to pursue a COVID-19 case. And I think it's going to be difficult to prove that people who've gotten COVID-19 while working. I think the best opportunity will be if you had a sick person and you had a number of people who worked in the same employer, at the same job, or in the same facility, or close to each other, who all got sick. I think you'd have a much better opportunity to show that they all got COVID-19 through their work.
Yeah, I know that the federal government has talked about waiving all medical costs or medical fees to the individual that has COVID-19. Let's see how that plays out, because there could be some significant cost to people. So even if you're out of work for 3 weeks, you could have thousands, if not tens or hundreds of thousands of dollars of medical bills, depending on how severely you catch it.
Right, and of course the problem in Georgia law from the attorney standpoint is that attorneys are not able to recover attorney's fees for obtaining medical for our clients. So even though it's very easy to say, well, we should do it to help people, and I certainly understand that, if it's going to take a lot of effort and you have to pay for experts and things like that without any opportunity to get a fee, it's hard to find somebody who's going to want to take on a case like that.
Well, if anyone has any questions about workers' compensation, which as it relates to COVID-19 or anything else, please don't hesitate to contact us here at Gerber Holder. Thanks, everybody.